we ready? Yeah? Steve, you ready? Okay, the August 8th meeting of the Rent Control Board is called to order. Would the secretary please take the roll?
Commissioner Duran.
I am here.
Commissioner Foster.
Here.
Commissioner Phyllis.
Here.
Commissioner Sultan.
Here.
And Commissioner Trosis.
Here. Okay, so we will now do our salute to the flag, and then I have a couple announcements. For those of you who are here to speak on item 14, we are pulling that from from tonight's agenda, so just wanted to let everyone know in advance in case you're here for that. All right. May I have a motion to approve the minutes from our last meeting in July?
I will so move.
Second.
Okay, all those in favor?
Aye.
Aye. Seeing none opposed, that motion passes. Special agenda items, do we have any, Ms. Condon?
Yes, thank you. Just 2 items this evening. Registration fees were due by August 1st, and I'm happy to report that about 95% of the fees have been paid. But for those owners who have not yet paid their fees, they cannot notify the tenants of rent increases until they are in compliance with the law, which means having paid the fees. If you have any questions about that, property owners can contact the Rent Control Office. And the other thing is, if owners or tenants have any questions about the rent increase notices that have gone out or will be going out soon, please give us a call at the Rent Control Office at 310-458-8751 and speak with an information coordinator. And that's all I have this evening.
Thank you so much. Any questions? No. All right. Now I'm going to go ahead and move on to items 10A, 1, 2, and 3. Before I do that, do I have any?
Public comment.
I'm so sorry about that. Public comment. We do have one item for public comment. This is our time reserved for members of the public to address us on items not on tonight's agenda. Ellen Achtman, you have 3 minutes. And please approach the podium just so that we can record everything you're saying and our beautiful city TV can broadcast you.
Okay. I'm asking for some clarification about temporary relocation assistance. The situation is it's a high-rise building, 19 floors, 15 floors of tenants, roughly 280 units. A recent fire, due to a recent fire, the 2 elevators serving the buildings were down for several days. And there has been some question among the tenants as to whether that renders the building uninhabitable. We were told by our landlord that code enforcement had decided the building was still habitable, and when I spoke with Ada Gonzalez, she confirmed that. And at the time I asked her whether my fellow tenant who lives on the 8th floor and was waiting for hip replacement surgery would be deemed ineligible, and was told yes. No, I'm sorry, was told no. That if the code enforcement officer had decided this, it was a no. So if indeed we were eligible, how many tenants, which sorts of tenants from the 3rd floor above, only if you're handicapped, et cetera. And is the landlord legally obliged to inform tenants in writing about their right to relocation, or is it up to tenants to request it? If tenants are eligible and the landlord decides to give per diem money, does the landlord have to pay up front, and within what period of time? Or can the landlord demand that tenants pay and the building will reimburse them? If the code enforcement determination violates city statutes or state or federal, who can renters appeal to? And then I have one question, which is slightly different. We now have in my building, one elevator is under repair, and it'll be about 3 months before it's repaired. The other elevator is works some of the time, but for instance, this past week it was out for 2.5 days. In a situation such as that, is the landlord obliged to give a rent reduction, or do the tenants have to request one? I think that's it.
Thanks for your comments. I do believe we have a couple of people in the queue who want to make an additional follow-up. Mr. Lewis, do you want to go first?
Yes, I just wanted to tell the speaker that the board doesn't deal with relocation benefits, but staff would be happy to put you in touch with the appropriate people who do, and would also be happy to answer your questions with respect to your rights under the rent control law regarding a rent decrease. The board can't really engage with you about the specific situation in case something comes before it that deals, if suppose there is a case that that you decide to pursue, or other tenants in your tenant decide to pursue. It wouldn't be appropriate for them to discuss it now in advance of that.
Conflict of interest?
Right, but I'd be happy to talk with, or I or other members of staff would be happy to talk with you at the office or after the meeting.
Wonderful.
Mr. Costello had already nodded in excitement to talk with you. Yeah, Commissioner Phyllis?
So I just had a quick question. So are the elevators were down for like 7 days?
Well, initially, I don't remember the specifics. It was back in April, and it was due to water damage when a serious fire was put out. They were out for, I believe, 2.5 days before they were able to be operated.
Just in case this comes.
Yeah, no,
Okay.
my only question
Okay.
was like,
Okay.
is this an emergency? Are they operational now?
Yeah, is it a public health
They're-
emergency?
One of them is completely down for the next 2.5 months. The other one works sometimes, but for instance, my neighbor who just had his hip replacement needed to see 2 doctors, and the elevator
I just-
was down. Both elevators were down.
And we're totally, if this comes before the board, we're totally happy to hear all the details.
Okay,
We just want
I
to
don't
make sure
wanna
that
bore
we're not hearing anything when it's not properly noticed before the board.
And
Okay.
Mr. Costello can get into that with you, though.
Okay,
No
great.
problem. Okay, thanks for bringing that to our attention. That's why we have public comment. Okay, I believe that's it, unless we don't have any late chits. It does not appear so. We're going to move on to the 10 series of items. Before we do that, do I want to entertain any motions or no? Okay.
Me?
Sure.
So at least 2 of the jurisdictional items for owner occupancy exemptions seem exceedingly clear cut. And one has 0 tenants in question to disagree with anything the staff has reached, and the other one, they both seem to be in line. I would say that we grant item 10A2 and 10A3, but I wouldn't mind hearing the staff report on 10A1.
Okay, and we do not have any public comments on any of these matters, just clarifying. Is there a second on that?
Or I could be persuaded not to hear 10A1.
I'd move not to hear. I think A1 through 3 is clear. Although if there's an objection, I'm happy to withdraw it, but I think A1 through 3 is clear.
My reasoning was
I
only
do
that
wanna hear the
we
appeal.
we denied the petitioner in 10A1 last time, so I thought for the public's edification, they might want to know why it's being granted the second time.
Yeah, I mean, I think our regs are clear.
Well, let's not
I'd
discuss, but
Okay. So I would move, because I think A1 through 3 are clear and there's no dispute on the regs and no dispute on facts, that I would move to accept grant A1 through 3.
I would also second that. I
That's
didn't
fine.
find anything that needed to be discussed.
all right, let's do it.
Can we call for a vote?
Commissioner Sultan?
Yes.
Commissioner Phyllis?
Yes.
Commissioner Foster?
Yes.
Commissioner Duran?
Yes.
And Commissioner Trosis?
Yes,
Motion
Mr.
carries.
Lewis, that's because I didn't, okay, all right. Yep, thank you. All right, great. Moving on to 10B1. This is an appeal at 919 20th Street. Can we hear a staff report, please?
Good evening, Commissioners. Before I begin the substantive part of the staff report, the Skibinski's son has submitted new evidence with his written report, basically a tax return and declarations from places that Ms. Skibinski volunteers to support their claim that Santa Monica remains their principal home. Because these records could have been submitted to the hearing officer but were not, staff recommends that the board reject their inclusion into the record, but I do need you to first decide on that.
Any comments? I have no objection to that.
Oh, sorry, I agree with staff.
I do not need to admit it into the record.
Usually, I believe you do a motion on.
Thank you. Do we want to entertain a motion?
I would move to not accept the late evidence and to agree with staff's assessment.
I don't see any reason not to agree with that, so I second. Can we call for a vote? Sure. All those in favor?
Aye.
Aye. Great. Unanimous.
Thank you.
Please continue.
After Robert and Suzanne Skibinski retired in 2012, they moved from Massachusetts, where they had lived much of their lives, to Santa Monica to be close to their son and his young daughters. At the time, their son's LLC owned the property, but since 2016, the property at 919 20th Street has been owned by the Lowe's. The Skibinskis were away for extended periods in 2017 and 18, so the Lowe's have petitioned the board to find them as tenants not in occupancy and to adjust their rent based on market rents according to Regulation 3304. The record does show that the Skibinskis were in fact away for extended periods in the last 2 years. In 2017, they went back east in the summer from May to September, and again for the holidays in late November to January of the following year. Last year, they went back east in April and May, and again in the summer from June to October, and for the holidays in December and January. The question before the board is whether the record shows that they no longer principally reside in their Santa Monica apartment. The fact that they were away for extended periods in the last 2 years does not necessarily mean that they have stopped living in Santa Monica as their primary residence. Regulation 3304, in fact, excuses extended absences for reasons such as hospitalization, vacations, and family emergencies. In the summer of 2017, the Skibinskis vacationed back east to attend 2 of their grandchildren's graduation and to go on their annual family trip to their daughter's place in Maine. Mrs. Skibinski testified that they stayed longer than they had intended because a doctor in Los Angeles had recommended surgery for her knees, and she sought a second opinion from a doctor in Massachusetts. That doctor wound up recommending physical therapy instead, which she initiated there and continued back in Santa Monica. The Skibinskis' second long trip that year was during the Thanksgiving to New Year holiday season. Last year, they went back east to see their young nephew who was hospitalized with a terminal illness and passed away, and for Ms. Skibinski to go on her pre-planned trip to Italy. They returned in June of that last year for their summer vacation to attend another grandchild's graduation and to go on the annual trip to Maine. Mrs. Skibinski, however, sustained a hip fracture during the trip and broke her foot, and Mr. Skibinski had heart surgery that was delayed to September due to Medicare's delay in approving the procedure. So their trip was extended longer than they had anticipated. Then they returned as they always do for the Thanksgiving to New Year holiday season to be with their family. All of these trips were for vacations and medical treatments, and in one unfortunate instance for a family emergency. The hearing officer, based on that record, denied the Lowe's petition and found the Skibinskis to have continued to principally reside in Santa Monica. The Lowe's have appealed that decision. They argue that the Skibinskis failed to provide verifiable medical records to substantiate their medical claims. In fact, however, the Skibinskis offered to submit voluminous records, and it was counsel for the Lowe's who agreed that the submission of the records was unnecessary due in part to privacy concerns. The Lowe's point out that the Skibinskis still have a home in Massachusetts with a declaration of homestead. The Skibinskis admit that they still have a declaration on the property, which is the only one that they own, but that it does not provide them with a reduction in taxes, but is there for other financial legal protections. Moreover, they testified that they rarely stay in that home when they visit Massachusetts. Their granddaughter and her boyfriend live there, and they usually stay with their daughter and only occasionally with their granddaughter in the home that they own and when her boyfriend is away. The Lows point out that the Skibinski's driver's license are issued by Massachusetts and that their vehicle is registered there. Mrs. Skibinski responded that they did not know that they had to re-register in California and that Mr. Skibinski barely drives anyway. The Lows point out that the Skibinskis file their taxes in Massachusetts. Mrs. Skibinski explained that they live on a modest income of pension and Social Security, and since they spent all their working years in Massachusetts, they still file their returns there. Their son also testified that his dad is just very set in his ways and has always filed his taxes in Massachusetts, and that because he's done that, that's what he's continuing to do. The Skibinskis also said that they have a bank account in Massachusetts because their daughter, who lives there, handles their bills, and that's also where the credit union is that Mr. Skibinski's pension has always been directly deposited into. The record also includes testimony of witnesses as to Mrs. Skibinski's close relationship with her granddaughters in Santa Monica, her new close friendships she has developed here, and her volunteer work. The record also shows the relationship she's developed with local health and dental professionals, including regular immunology treatments at UCLA. The board's regulation makes clear that a tenant does not have to live full-time in a control unit for it to be his or her home. Case law in Bisno versus the board held that the rent control law is meant to control the cost of a tenant's principal residence, not a vacation home. But here the record shows that the Santa Monica apartment is their home. Where they go on vacation is in Massachusetts, where they've lived most of their lives, to visit family and friends. They have also been away longer than they would have otherwise for medical problems that are unfortunately common to an elderly couple and for which they have sought treatment from doctors in Massachusetts that they have known for years or because of injuries sustained during their visit. They also visited back east because of a family emergency, the terminal illness and ultimate death of a nephew. Given this record, the hearing officer concluded that a preponderance of the evidence shows Santa Monica to remain as a Skibinski's residence of usual return. The board reviews this matter as an appellate body, so it should only reverse that conclusion upon showing of clear error. Because the record reasonably supports the hearing officer's conclusions, staff recommends that the board affirm the decision.
Thank you. We have, let's see, 2 public comments. Rosario Perry, you have requested 5 minutes, I believe, representing the appellant here.
Oh. Am I, it's print side up, correct?
Yes. Oh, turn it. Yeah, looks like
If I hit it, I'll break it.
Okay. Somebody moved it. Yeah, I know. Oh, here we go. We're getting there. Now we're getting.
I see.
And I can.
Mathematical calculation.
Yeah. Okay, good.
I wanted to do landscape, I could do the other way, another.
No, that's all right. Because I can manipulate it over here.
Good afternoon, good evening, Rosario Perry for the owners. What I want to present in 5 minutes is not to fight about the facts, because I think the facts are pretty close. We agree on the facts, I should say, pretty closely. I want to emphasize to the board that since you're a neutral body and deciding as a referee would, both sides have to be honest and direct and held to high standards of consistency if they're going to present the cases or if they're going to oppose cases. Now, the first chart shows, based on the hearing officer's decision, the days in and outside of the apartment Santa Monica for the calendar year 2017, 18, and 19. And it shows the percentages of time in bold outside, okay? So 50%, 50.4% more 2017. 2018, 58% of the time they were outside of Santa Monica. 2019, they were 54%. Now, I used through today, or actually through Monday, because they weren't back yet. Mrs. Skabinski, I'm sure, returned for the hearing. She did that also during the hearing at the hearing officer's hearings. So it's pretty close in terms of time in and out, but clearly more time out. Doesn't really mean much in terms of counting days. But I want to explain the next slide. And this is where we get to honesty, and also we all have to be held to the same standards. So you can see the contacts with Massachusetts. They're both driver's licenses at all times have been from Massachusetts. Even though the husband may not drive much, the wife testified she drives all the time. She owns a car in Santa Monica, Massachusetts driver's license. She's told the state of California, basically, and the state of Massachusetts, that she lives in Massachusetts, because if she lived here as a primary resident, she'd need a California driver's license. The registration, Massachusetts. They own their home in Massachusetts. Declaration of homestead under penalty of perjury states their primary residence is Massachusetts. Now, they say it doesn't mean anything. I say it means a lot, because they're entitled to tax benefits if their primary residence is Massachusetts from the state of Massachusetts. And we gave you information from the state of Massachusetts. You can take judicial notice of that. They're telling the state of Massachusetts they're residents of Massachusetts. They're telling the state of California they are not residents of the state of California. Look, number 5, the state and federal income tax returns are filed in Massachusetts. Well, it's an old habit. We made the money in Massachusetts. We're going to pay Massachusetts taxes. Of course they are. Nobody wants to pay California taxes. It's 13% of income. But they have represented to the state of California they are not residents of California under penalty of perjury by filing the tax returns in the federal and state tax returns in Massachusetts. You have to tell the state of Massachusetts you're residents there. So the point I'm trying to make is they've made substantial statements under penalty of perjury that they are residents of Massachusetts. And now we come to the last slide. The law of estoppel. Now, I'm not arguing, because I know the board's very sensitive about this, I'm not arguing the board should be estopped. I'm arguing the tenant should be estopped. Because when the tenant makes, that's the California law. That's the Evidence Code section 623. When a tenant makes a statement like that under penalty of perjury repeatedly in everything they do, and they're not paying taxes in California, and all the things they're doing, and they should be estopped from now coming to you and testifying under penalty of perjury their primary residence is California. And let me explain, the 46 seconds left, let me draw your attention to the board regulation, which I think is important. All the board regulations are important, but this one especially. All right, 3304E says, the landlord's got the burden of establishing a prima facie case. So we did, because what that means is don't look at any evidence the tenant does, just look at so the evidence we presented without any evidence from the tenant, of course, that's our prima facie. Once we establish a prima facie case, the burden shifts to the tenant to prove that the unit is their usual residence of return. So that's where they're stopped. They're not allowed to present evidence under penalty of perjury that would contradict statements that they've made repeatedly to the state of California and to the state of Massachusetts. Thank you very much.
Thank you, Mr. Perry. Always entertaining. Oh, we have a question.
So I think in the beginning, well, actually, I want to start with, there's no evidence in the record that they have some other residence in Massachusetts or somewhere else that they go back to that would be their permanent residence, correct?
No, wrong. They own a house. They stay there. She testifies she stays there all the time when she goes back, but she let her niece move in for a while, but she also testified her niece was moving out, and she intended to stay there again when she went back.
Okay, so there's a family home somewhere else. Is it your contention that that is their permanent residence? No, just like yes or no. So that's your contention.
That's the Homestead house.
So you're saying that's their permanent residence?
Correct.
Okay. And then I also want to clarify that you said it's pretty close, at least in terms of on the evidence, whether they do or don't live here.
No. Well, the timeline.
You did say it's pretty close on the timeline, and you also said pretty close on the evidence, right?
I said the evidence is not disputed.
I think you said pretty close, but we can
Fine.
play it back.
It's not disputed. I'm not arguing with the evidence.
Okay.
I'm arguing with the law.
But it is pretty close on the timeline. You did say that, right?
58%, 50%. The graph shows, yes, exactly.
Okay. Thanks.
Thank you. We have Bob Sabinski. I believe you've requested 3 minutes.
I don't get 5 minutes? I'm sorry. Okay.
No, because you're not the appellant. Sorry.
Okay. So I'm not an attorney. I'm here on behalf of my parents. Couple things. The facts are disputed 100%. Mr. Perry, in his appeal, suggested or actually stated that my parents offered no verifiable proof of their medical records. I had a stack this large in the hearing. He decided he didn't need them. My mother is one of 9 kids. I have 26 first cousins back east. There's multiple great-grandchildren that are her siblings' kids. My parents have had health issues. I've had relatives that have died. My sister is there with my niece. It's not her niece that lives in my parents' house back there. It's her granddaughter. Bear with me because this is the first time I'm dealing with something like this. My parents bought their home in 1968 back there. They paid $19,000 or something like that. It was paid off in 1996. I provided information recently with tax returns only to show that they're not wealthy. They don't travel the world. They basically live month to month on my dad's pension. One of the other things that I included in this most recent thing, which I realize is not allowed, is that we tried to get people to come to the hearing and they wouldn't or couldn't at the time. My mother volunteers at the Cancer Discovery Shop in Santa Monica on a regular basis. She's an ombudsman. She works at nursing homes in Santa Monica. We have proof of that. We've offered that proof. As far as the license goes, they didn't think they needed one. Well, I found out recently that we can register the car in California. They don't need to have a license in the state of California. Regarding the Homestead Act, I didn't know anything about it. The Homestead Act simply says that's one asset, their only asset they have. They have no other assets. They have no money. They have nothing else except that one house in Massachusetts that my niece lives in. That is there to protect them in the event of a bankruptcy or a personal tragedy. It's not a tax exemption. It's not cheating the government. My parents are more involved in the city of Santa Monica probably than most people that live here. They don't leave the neighborhood. They go to all the businesses. They're patrons of all these institutions. And to suggest anywhere that we are cheating or they are cheating the system and making the board or the Santa Monica Rent Control Board look bad is absurd. And honestly, it's appalling what they put my parents through for the last 2 years. That's it. Thank you, though.
Okay, thanks for your time. Commissioner Phyllis, is this a question or okay, all right, we don't have any further questions.
Okay.
Thank you for your time.
Thank you.
All right, so Commissioner Phyllis is ready to make a comment.
Yeah. So I guess on the evidence, I'm not bothered by the fact that they have a home in Massachusetts. I think that it's very clear that that home is a passive investment, that they're not looking at it as a residence. They're looking at it as a investment in real property in the same way that people invest in funds or whatever. What's actually most compelling is the fact that our standard of review is extremely deferential. We have to have no possible reasonable basis. And Rosario Perry got up there himself and said, well, it's pretty close. I think that concedes it. No question to me that they are absolutely tenants in occupancy. There is no way that someone can get up here and say it's a pretty close call. You should reverse and also argue that there is no reasonable basis in the record on which to uphold this decision. I'm very clear. I'm ready to uphold the decision, finding that they are tenants in occupancy, and I look forward to hearing my fellow commissioners' comments.
Great, Commissioner Foster.
In the past, so I echo what Commissioner Phyllis has already said. In the past, this board has heard, in my 3.5 years or 3 years on the board, we've heard numerous cases like this, and we have sometimes found for the tenant, we have sometimes found for the landlord, whenever the facts follow our law. And in my mind, there is no doubt that these tenants reside in this apartment as their intended place of return. And I have other things I'd like to say, but I'm not going to. I am completely convinced that these tenants do live in their unit, and that's how I intend to vote.
Commissioner Duran.
Yeah, thank you. I'm persuaded by the first of all, there's a standard that with which we have to use to determine the outcome of this case, and based on that standard, and based on the appellant's counsel's admission that the facts being close, I can't see how it then can be unreasonable in a way for me to not affirm the decision made by the hearing officer. So using the words of appellant's counsel, it's close call. It sounds to me that it's reasonable, and since our standard is only to reverse if we find something that's unreasonable, I can only see affirming the decision, and so I'm ready to vote on that basis.
Thanks, Commissioner Duran. Commissioner Sultan.
Thank you. I agree with Steve. I mean, I think I may find that the actual evidence is closer. It seems like if I were just the original hearing officer making the decision, I think it would be difficult for me to figure out how I would decide. It seems like there's potentially 2 residences, and they split their time between them. But given that we have this decision on the record that we can only overturn based on clear and convincing evidence that it's wrong, I think it's that standard that dictates that we affirm this decision.
Okay. Oh, Commissioner Duran, did you want to say something else? Okay, and I would just say that, again, irrespective of my personal opinion, we can only overturn this if there is a clear error. I do not believe there is a clear error. There is an intent to return and reside in the location as the Skibinski's residence, and so therefore I would agree with the remainder of my commissioners. Did you want to make a comment, Commissioner Duran? No. Okay. Do we have a motion?
I'll move.
Second.
I'll move.
I'll just do.
I'll move that because the record reasonably supports the hearing officer's conclusions, I move that we affirm the hearing officer's decision.
Great. Can we get a vote, please?
Commissioner Foster.
Yes.
Commissioner Duran.
Yes.
Commissioner Phyllis. Commissioner Sullivan.
Yes.
And Commissioner DeRosa's.
Yes.
Motion carries.
Great. Okay, and again, as stated previously, we are pulling board discussion item, so 14A is pulled. So now, do I have a motion to adjourn?
So moved.
Second.
Great. All those in favor? Aye.
Aye.
We are adjourned. I think this is the shortest meeting I've ever been a part of. Great.